I humbly announce my appearance for the defendant, Professor Wale Olawo, and with me and my learned friends.
May I get the surname, please? Wale
Olawo.
Yes, please.
With me and my learned friends, O Okene and D Monwe.
Monwe.
Monwe. MONWE. For the defendant. I'm not speaking somebody.
Mr.
So the matter is slated for trial today, sir. We are ready, subject to your lordship convenience, sir. As a position, sir.
Yes, so we're going to do what we're able to do in the circumstance. So the witness is Mr. Wonye.
Yes, sir. And it's the claimant, sir.
Registrar. So, Mr. Wonye, can you hear us? Can you unmute yourself?
Yes, my lord, I can hear you.
We're going to give witness you. We need you to either swear by either the Bible or Quran or affirm. Which one do you want to do?
I can affirm. I can swear on the Bible.
You have a Bible?
No, I have my iPhone. My Bible is electronic.
If you don't, then you will affirm them.
Okay, yes. As a call, please.
Okay, so you listen to the registrar and you repeat after him.
Do you have any? Is that family?
Yes, sir.
Okay. You repeat after me, sir.
All right, sir.
After you name is full. I,
Idigbe Stephen Woye,
affirm that evidence I shall give in this case
that the evidence I shall give in this case
shall be the truth,
the
whole truth, and nothing but the truth.
And nothing but the truth.
Mr. Atta, what date is on his deposition?
It's dated 6th of August 2021, sir. On the 6th of August 2021.
Yes, proceed, Mr.
Please, Mr. Stephen, can you tell the court?
So that you will sit down so that you can have facial contacts. Sit down.
All right, sir. Thank you, sir.
Please. Much obliged.
Please, Mr. Stephen, can you tell the court your full name, your address in Nigeria, and your profession?
My full name is Mr. Idigbe Stephen Woye. I'm a Christian Nigerian citizen of Plot 8 Providence Street, Lekki Phase 1, Lagos, which is my law office address. And I'm a legal practitioner called to the Nigerian Bar on January 2022.
What did he say? His address? Vineyard Place.
8 Providence. 8 Providence.
8 Providence.
Yes.
Lekki Phase 1.
Phase 1. Lagos State.
So let us have the address where it is now.
Please, can you kindly give us your current address where you are outside the country?
Okay, I'm currently based in the United States. To be precise, I am at 211 Fairmount Avenue.
Can you take it easy?
Take it easy. Recording you, sir.
So
I'm currently resident. I'm currently resident in the United States, in the state of New Jersey.
State of New Jersey.
Yes.
Yes, sir.
The precise address
where
is
in New Jersey?
211 Fairmount Avenue.
211
Fairmount Avenue.
Fairmount.
Fair, as in being fair hearing, Fairmount, the mountain. Together, compound.
FERMOUTH or FAR?
FAIRMOUNT, Fairmount Avenue.
And okay, Fairmount. 211 Fairmount, yes.
Yes, Avenue. Avenue as in AVENUE, Avenue.
Yes.
Newark.
Newark.
State of New Jersey.
Okay.
All right. You recall making a deposition in respect of this case stated on the 6th of August 2021.
Yes, I did.
If you see same, can you identify it?
Yes, I can.
Yes.
I believe you have a process with you over there. Can you confirm your signature on it?
Yeah, it's my mark, or it's my signature.
All right.
What date?
6th of August 2021.
So do you have a copy there so that we're sure we all have the same document? Mr. Olome. Sure, counsel, so that we're sure we have the same document.
I confirm it's the same one. I must apply now.
That's good.
What do you want to do with the state deposition, sir?
I want the Honorable Court I want to adopt same as my witness statements on note in this proceedings.
We humbly apply to tender the deposition, sir.
No, we'll rely on the fact.
All right, as a complete.
As the court pleases.
You refer to some document in your deposition. Can you confirm that part?
Yes, I did. About 10 documents.
There are about 10 in number.
Yes.
All right, sir.
Yes.
In paragraph 2 of your witness statement on oath, you referred to a dispute settlement agreement.
Yes, I did.
Executed between your humble self and some of the defendants in this matter, sir.
It was executed by myself and partners, and SY partners of the defendants. The defendants is the law firm of everybody.
Yes.
Please, my lord, can I just give assistance to the court? I think that the claimant has 10 documents, as he said. We're not objecting to the admissibility of those 10 documents. He has prepared a list. Maybe he can make it available to the court so that I will just assist my lord. Been asked as well. So that I will assist my lord in quickly admitting the documents so that we can.
We are very grateful. We have the list, the 10 documents here with us, sir. I like to tender them from the bar since they are not opposing the sage document. So we can proceed. Thank you, sir.
What about certification?
No, sure. You know, sir, I just wanted to be guided further, sir. Most of those documents there, by virtue of Section 84 of the Evidence Act, we need to lay foundation to their admissibility. I just wanted to be guided so that it will not bring surprise to us at the end of the game, whereby the written address, the learned chief would be addressed in the court on the nature of Section 84. I just want to be guided whether or not it will be countenance with plain foundation to their admissibility, since the learned senior advocate is not opposing to their admissibility. I just want to be guided because that position.
Yes, the professor has said that he's not objecting on any ground. So I think that means you cannot object after now.
As a company, of the court, I'm very grateful. I just want
because what I have recorded is we do not object to any of the documents on any ground.
As a company,
thank you. And I can even state it on the record clearly that I do not intend to raise any Section 84 of the Evidence Act issues.
Maybe
so
that,
yes,
yes, sir.
Beyond the argument.
To the whole exercise, sir. Thank you.
The documents are all admitted and matched to the C1 to C10. The other they are listed.
All right, thank you, sir. C1 to C10.
There's a letter, there's 21st May, number 6 on your list.
Uh, 21st of May, sir.
So I'm marking it using the list here.
Yes, sir.
Oh my God. But I cannot find the letter of 21st May.
The letter,
Okay, no, rather. Okay, it says attachment letter dated 21st May. Where is the attachment?
I think it's part of the letter, the right of there that forms part of the attachment.
Forms part of
The attachment that the mail intends to refer to. Otherwise, there's no any other attachment to the document I have.
so we don't have the letter then.
So that is very good. A letter dated
If you
May.
look at your list of documents, number 6, a copy of the claimant's letter dated 21st May, an email. So I have the email. An email through which the letter was sent. So I have the email, but there's no letter. So that we're
That's
all sure that of what I have.
Yes, my lord, in that circumstance, we'll just we'll take the hint of the court so we can reconcile our documents, and then I'll speak with Mr. Stephen so we can avail the court that document, that particular attachment. Maybe by inadvertence we fail to front load it, but I promise to punish the court. The
Well,
stage
21st piece is part of the processes you front loaded.
Yes.
It's front
We
loaded,
need-
but it's not part of the exhibits you have tendered.
Yes, we've listed, but by inadvertence or human error, we omitted to attach it, sir. We are very sorry for that. And I want to plead with the court to give us the grace to punish the court that particular document. I want to reconcile the document with the claimant. I can punish the court on the next day, sir. I'm very sorry for the inconvenience.
Prof, you understand the point I'm making?
Okay, I fully understand,
Yes.
but I would not object to his application.
So it means the witness will not be cross-examined today.
I can say that I was not confirmed the witness of that document. So that's why I'm allowing you to go.
Okay, so do we
As a couple, no objection. No objection.
Thank you, sir. I'm very grateful, sir. Thank you, sir.
accept it later when it comes? That's how you send it to the registrar, will attach it to this.
As a couple, I will punish the court, sir.
Let's put this together. The letter and the email. Mr.
Yes, sir. Please, Mr. Stephen, are you there?
Yes, I can hear you loud and clear.
Please, what do you want from the court, sir?
I would want to humbly pray the court to grant the release sought in the general complaint form and the statement of plea.
All right.
I didn't hear you, sir.
My lord, I said I would want to humbly pray the court to grant the release sought in the general complaint form and the statement of plea.
Yes, a lot of that will be all on the part of the claimants.
Thank you, my lord.
So we'll give you 25 minutes.
It should be done in 25, 30 minutes maximum, my lord. I'm much obliged, my lord. Good morning, Mr. Nwoye.
Let us say good morning, sir. So good to see you.
Good morning. Thank you for joining us at about 6 a.m. Same here. Thank you for joining us at about 6 a.m. your time. I wouldn't take much of your time, as I said to the court. I just have a few questions for you. So my first question, Mr. Nwoye, is that do you know the accounting firm KPMG?
Yes, I do.
Yes. Do you agree with me that KPMG?
KPMG.
G. Yes, ma'am. Mr. Nwoye, do you agree with me that KPMG International and its Nigerian affiliates are regarded as one of the top 4 accounting and tax advisory firms in the world?
Yes, that is a notorious fact. Yes, I do.
So, Mr. Nwoye, you would agree with me, wouldn't you, that any opinion or advisory from KPMG on tax matters is worthy of serious consideration and respect?
Yes, it's my answer to that question is it would on a normal course of events take more or less attain the prominence of respect and recognition. But however, it doesn't mean that human error it's far proof. That is my caveat to that statement.
So you
Just give me time.
Mr. Nwoye, I would prefer a yes answer first before you explain, if you want to explain. I just want you to accept that any opinion or advisory from KPMG on tax matters is worthy of serious consideration and respect.
From officially, yes.
Thank you.
It's worthy of
Serious consideration and respect.
And my response is prima facie yes.
Your answer is yes.
Prima facie yes. Prima
Sorry?
facie yes.
Facially, yes.
Prima facie.
Yes.
Yeah.
Yes.
And Mr. Moye, you also agree with me that the law firm of Alukano Yebode, the defendant in this case, is a leading tax advisory law firm in Nigeria.
No.
You don't agree?
Yes.
Yes, sir.
Thank you, ma'am. So, Mr. Moye, you joined the law firm, you first joined the law firm of Alukano Yebode in 2012.
Yeah, 2012 January.
And would I be right in saying that you were very happy and you had a sense of elation when you joined the firm of Alukano Yebode in 2012?
Let us say I didn't get the question. There was stats in the conversation.
I said that would I be right in suggesting to you that you were very happy and indeed you had a high sense of elation when you joined one of the top law firms in Nigeria?
Yes.
Correct.
And indeed, you felt the same
And
way when you went back in 2016.
indeed, you felt the same way when you went back in 2016.
2016 was under special circumstances.
So you were not happy.
So you were not happy rejoining Alukano Yebode in 2016?
It was a compromise. It was a compromise decision and a compromise meeting that led to my return to the firm. But anyway, it was a career move, and I wouldn't say I was sad or I was maybe excited. It was a sober, conscious, well-discussed return on negotiated employment in 2016.
So it was a sober and
It was a sober and well thought out.
and
Well thought out.
Well thought out
sober
decision.
and well thought out.
Thought out decision after meetings and discussions we had with the management team.
It was a sober and well thought out decision after what?
Meetings with the then management of the firm.
Yes.
Where we are coming to where we are today, as a result of your perceived grievance
arising from your inability
with the pay your school fees in New York at the relevant time, which you claimed was the fault of the defendants. You wrote a number of petitions with different authorities and agencies.
correct?
Yes, lawsuits were filed and complaints went out to regulatory and law enforcement agencies. Yes, that's correct.
You wrote petitions. That's what I need to establish first. You wrote petitions.
Yes.
So let me get the question.
So my question to you was that as a result of his perceived grievance against the defendant, arising out of his inability to pay his school fees for his LLM in New York, which he claims to be the fault of the defendants, he wrote a number of petitions to different agencies and authorities.
Oh, yes, as a result of my perceived grievance against the defendant arising from my inability to pay my school fees in New York, which I attributed to be the fault of the defendant, I wrote a number of petitions.
And lawsuits were filed.
Sorry?
I know my record was that petitions and lawsuits civil suits were also filed in court to seek legal redress.
Okay, you wrote a number of petitions and filed a lawsuit.
And lawsuits were filed in court to seek redress.
Yes, we'll come to that, Mr. Onwoye. So, part of the petitions, or one of the petitions that you wrote was to the Legal Practitioners Disciplinary Committee, correct?
Yes, I did.
Yes.
You also wrote to the Securities and Exchange Commission.
To the Nigerian Police Force and the Security and Exchange Commission, yes.
Security and Exchange Commission.
And the Nigerian Police. And the Nigerian Police Force.
Yes.
You also
petitioned authorities in New York, including the president of the American Bar Association.
The petition went to the New York State Bar, and the way the bar is structured here, the ABA is just more an advisory body, but more or less the petition went to the New York State Bar.
Yes. So you petitioned the Chief Attorney, State of New York, Supreme Court, and then after the petition, you copied the president of the American Bar Association.
Yes, that's a statement of fact.
Yeah.
I also petitioned the American Bar Association.
the Chief
New York
Attorney
of New York Supreme
of New York Supreme Court.
Disciplinary Committee, the New York State Bar Disciplinary Committee.
To the president of the American Bar Association.
Yeah.
And Mr. Onwoye, you also petitioned the National Executive Committee of the NBA regarding the chairmanship of the partners of the defendant as the chairman of the Technical Planning Committee of the 2019 NBA conference.
The answer to that question would be no. It wasn't a petition. It was drawing the attention to the fact that there was a pending LPGC inquiry that was already scheduled for hearing, and given the issues at hand, it would be more or less inappropriate for you to still be elevating the same person to the chairman of the Technical Planning Committee. I only drew the attention to the so that we had the different rules for disciplinary or for the discipline of lawyers. At that same time, the NBA was a judge in that case, not the current system where it has been moved away from the NBA. In the former rules, the NBA was the judge and the NBA was the investigator. And at the same time, while the NBA had already scheduled the hearing for the petition, the NBA was...
the mechanics of NBA disciplinary process. I just need to establish that you wrote a letter to the National Executive Committee, informing them and suggesting to them that Mr. Oyebode should not continue as the chairman of the TCCP, correct?
Yes, that's correct.
Yes, thank you.
To the National Executive
Committee of the NBA.
Yes.
that Mr. Gbenga Oyebode, one of the partners listed in this suit, should not be allowed to continue as chairman of the TCCP.
Oluwagbemika Oyebode is listed, not Gbenga Oyebode.
Chairman of TCCP.
For the 2019 NBA contract.
Yes.
In 2020, you filed a petition to wind up the law firm of Aluko Anoyebode in the Federal High Court, correct?
In 2019.
Was it in 2019 or 2020?
It was in 2019.
Okay, in 2019, you filed a petition
the law
to wind up this law firm.
Yes, that was alongside the pending proceedings at the NIC. So it was directly a debt recovery winding up proceedings for a specific amount, which is the liquidated claim.
Yes.
Before Honorable Justice Professor Dr. Chuka Obiozor of the Federal High Court.
So in 2019, I filed a petition to wind up the defendant before the Federal High Court.
Yeah, the Federal High Court.
You would agree with me that the court found that your action was lacking in bona fides and frivolous. Court in its ruling,
dismissing your winding up
found
that your action
was lacking in bona fides and frivolous.
Okay. Let us
yes,
we
yes,
have
yes,
or no.
Yes,
no. Let me clarify the question.
Just yes or no.
What the one you're referring to is the tax, the personal income tax issue that went to Honorable Justice Pagi.
That was when I said 2020, and
that was the one I said 2020, and you were
Okay, well, I think we're talking about the DSA related proceedings. If it's for the personal income tax dispute, yes, that's happened in that one.
Yes, so the
court found that your action was lacking in bona fides and frivolous and an abuse of court process.
Yes, that was what the court held.
Yes or no?
Yeah.
Yes.
Thank you.
That's the 2019 suit?
2020.
Yeah, 2020.
And my lord will see it in the record.
So I should say in 2020, I filed the petition, not 2019.
There's a 2019 suit, which is different from the one he's referring to. The 2019 suit was
the one that was found to be frivolous is the 2020.
Yes, it was.
Okay,
so
in the records, I should now have in 2020, I filed the petition to wind up the defendant.
Yes, that's the personal income tax related dispute.
Yes.
Yes, my lord. Just a few more questions. Mr. Nwoye, when you left Aluko Anoyebode, you joined the law firm of Odita.
Odita Company. Yes, I did.
And
precisely on November 2017.
Okay. And sometimes in 2019, you were dismissed from that law firm.
Well, yes, and that is subject to litigation at the
I
NIC.
joined the law firm of Oditan when?
There is a different company
What
on
year?
November 2017.
2017.
Okay.
November 2017.
November 2017.
Yes.
Then the next question was whether he was dismissed from the
Yes. 2019, and he said yes.
February 2019. 28th of February 2019. And that issue is the subject of a pending dispute before this honorable court.
What year was
it? It's sub judice. It's on February 28th, 2019. And that is the subject of suit number NICLA 100 2019. Pending before Honorable Justice
yes.
Yes. And suit number what?
NICLA 100 2019. Ikemefuna Stephen Woye versus and Professor Fidelis Adita, KCSN, and Johnson Abu. That is a pending suit before your brother Justice, Honorable Justice Salusi Danjida.
Following your dismissal, you also wrote a lot of petitions against law firm of Odita.
Doctor, I wouldn't answer that. That's not related to this matter. That issue is sub judice.
Mr. Oye, you have absolutely no right to tell me what questions to ask you. You must answer my questions. Even if you're a lawyer, you must answer my question.
Well,
and I repeat, let me finish. And I repeat, you wrote numerous petitions against the law firm of Odita and the person of Professor Fidelis Otita. Yes or no?
Sir. I have a line of
let me just give me a second.
It's sub judice.
Yes, what's up?
That question is irrelevant to the proceeding before the court. The law firm of Fidelis is the party in this case. None of the parties were pleading. We never pleaded that. Even in his deposition of oath, his character assassination, that line of question, because the witness had already told the court that the matter is pending before the court, and there is no any process to even show that matter is pending somewhere. So immediately that the court is now aware that that's the court is.
Prof, did you mention that fact in your defense?
That question is not relevant. The character assassination.
We are in court. There's no character assassination.
My lord, if you that, if you look at the line of questions that
if we confirm that it is in their defense,
yes,
in which case you would have also replied to it, then it is a relevant question.
Water, assuming it's in their defense, if it's a pleading emanating from their process, they can lay foundation to that. If they tender that the process is a copy of that pending.
No, but it is the witness. It's the witness himself that referred. It's the witness that referred to the suit and gave us the suit number to the judge.
The witness already informed the court that the matter is pending.
And number two, so how will Mr. Atta, how will this question prejudice the matter that is in court? If it can prejudice the matter that is before the court, that is why we say we cannot answer a question because it's so beautiful. Because we're also in court and it's in another court.
Yes, I agree.
So how can you now say because it's in another court you cannot give evidence here? You cannot be asked. So long as it is pleaded and responded to, then it's relevant to this case.
As the company,
More importantly, I've
company.
moved away from that. I've moved to the petitions that he has written against that law firm. And what I'm trying to do, my lord, here is to demonstrate a pattern and to discredit this witness. It's to demonstrate a pattern.
My lord, what did
And that's why I just asked him again, and go to his fault from this. He's going to come to confirm that his petition against
we're not going to look at the content of the petition. Just answer the question.
My lord, this matter is under criminal investigation by the state CID party. This matter is trying to refer to is under criminal investigation by the state PID. The person in question is under administrative bail.
But we need to hear this matter. You are the claimant. You brought the matter. Are we not going to hear it?
Well, my issue is the solicitor matter is currently under criminal investigation going on.
Mr. Wire.
Can you just stop? I will ask you that question again. If you decide that you don't want to answer it, I will move on. Did you write other petitions against Judicial law firm and Professor Fidelis Otita?
Probably this I cannot answer the question.
Okay, you can't answer the question. Thank you very much. That's all. Don't worry. We'll move on. Just a few more questions and I'll be done. In clause 6 of your written statement, and I hope you have a copy of your written statement with you there.
Yes.
Okay. You refer to a confirmation of performance of the PSA from the escrow agent as the basis upon which you took steps to discontinue the pending litigation at the time.
Yes.
That's correct. Good.
That's correct. Yes.
You referred to?
I refer to paragraph 6 of his witness statement of oath, where he said that the defendants confirmed their performance of clauses 5 and 6 of the PSA.
So you refer to the performance. No, I've started writing. But you asked him if you refer to the performance what?
Of clauses 5 and 6 of the DSA.
And he said yes.
Yes. From the escrow agent.
From the
escrow agent.
Escrow agent. You answered yes?
Yes, that's fine. I did.
Now, Mr. Owe, the performance of clauses 5 and 6 in the PSA that you are referring to was the payment of the Naira equivalent of $100,000 that was paid to you. That was paid to you.
Yes.
Yes, very good.
Let me get that.
The performance of clause 5 and 6 by the defendant was the payment of the Naira equivalent of 100,000 United States dollars that was paid to the claimant. And he said yes.
Free of all deductions. Yes.
The performance of clause 5 and 6 by the defendant was the payment of the Naira equivalent of $100,000 that was paid to me.
Free of all deductions. Yes.
So my last two questions, Mr. Onwe. Mr. Onwe, the defendant wrote you a letter
on the 2nd of June 2020.
on the 2nd of June 2020 before you filed this action, correct?
They wrote me a letter 2nd of June before we triggered the dispute resolution clause by going to the LNDC.
I don't know whether anybody is hearing Mr. Amoye, but I can't hear you.
Can you hear me now?
Yes.
Is it clear now?
He said the defendant wrote me a letter on
before the dispute resolution. Yes, before we commenced the dispute resolution clause, before it kicks in.
Before you commenced?
Before the dispute resolution clause was triggered by going to the LFC.
Okay, let me before the what clause?
The dispute resolution clause, clause 18
dispute
of
resolution
the DSA clause was activated. Yes.
And that was that you're coming to court.
No. We went to the LNDC with mediation. That was what parties engaged. Yes. Court administered mediation at the LNDC.
You went to
the Lagos Multi-Door Courthouse, my lord.
Okay.
It's not part of my question. I just needed him to establish that he received that letter of 2nd June 2020.
Yes,
I'm not disputing his articulation of the LMDC issues.
Okay, so the defendant wrote me a letter on 26th.
On 2nd June 2020.
2nd June 2020, before the dispute resolution clause was activated.
No,
yes.
I said before he filed this action in 2021.
Yes, Mr. Moye, before you filed the action.
Yeah, but before the action, there was a mediation process. A court was the last in the clause. So it's not as if the letter happened and then we rushed into court. There is a way.
His response is that he received it before
the letter was written.
Dispute resolution clause was activated.
Yes,
I
received that letter.
Courthouse. And then to this court.
Yes.
Top of my last question to you, Mr. Moye.
Yes,
did you ever respond to that letter of 2nd June 2020?
Oh yes, I did. My email was pleaded. Yes.
Did you respond to the letter of 2020?
Yes, I did.
Which email did you respond formally to that letter?
No, I didn't respond via letter. I responded via email.
Yes, which email?
Which date?
It was the email, if I recall vividly, that email was pleaded, and that's the email. That's the email of. Just give me a second. I want to get the exact dates, but I know I responded, and the email was pleaded. So he wrote the letter on 2nd of June, and it was delivered at my office. And in a response email, I think dated up that 2nd or 3rd of June, I responded to say I received this email, but I'm surprised at the fact that he closed, he usurped the whole powers of the court or even the mediator to say the dispute was closed.
That's fine. So you mean your letter of 5th of June 2020 was your response, but you did not respond to the substantive contents of that letter of 2nd June 2020.
So let me get his response was via email of 5th of June.
5th of June. A letter of 5th of June to the LMDC. Not to the defendant.
I responded via email of 5th June.
No, it was a letter to the LMDC.
Yes, a letter to the LMDC.
A letter to the LMDC. That's the Lagos Multi-Door Courthouse.
Yes, my lord.
But my lord, let me also clarify that there was a reply email of 2nd June. Where I acknowledged the letter and expressed my consternation over the usurpation of the judicial function to declare the dispute closed and a no issue.
Okay.
Because
My last question again to you, Mr.
Sorry,
Onwoye.
the last thing I have on record from him is that, yes, I responded via email
by email
to a late,
second.
by a letter to the LMDC. That's the last.
My lord, let me clarify.
He has now added another one that there was a reply email to the defendants on the 2nd of June,
acknowledging
the letter and expressing his consternation that they were foreclosing the LMDC
without
dispute resolution.
Yes. Correct, that's correct.
Yeah.
Then the letter from the 5th now went to the LMDC to begin the mediation process as provided under clause 18.
They were foreclosing
the LMDC.
The mediation process.
Yes. Yes, Prof. That should be your last question. We have done more than 40 minutes.
Sorry, my last question. So my last question, Mr. Onwoye, again, is that in your email response to the defendants of 2nd June 2020, you did not respond to the substantive response that they gave to you about the opinion that they received from KPMG. You did not respond to that.
No, I didn't. Because they closed it.
Thank you.
Thank you
very much. Thank you very much. That'll be all, my lord.
Regarding the report of, he said, in my email of 5th June to the defendant, I did not respond to the substantive content.
My email of 2nd June.
Second June, my lord.
I did not respond to the substantive content of that email regarding the
opinion of KPMG on the CGT issue.
On the CGT. What is
on
CGT?
The tax issue. That's stamp duty. On the tax issue.
On the tax issues.
Because they declared the dispute closed.
Any re-examination?
No, we don't have any to build our case further.
That's the case of the claimant?
Yes, that's the case. We only have one witness.
The witness is discharged.
As call, please.
On the call, please. Thank you, my lord. Much appreciated.
31st January.
It's convenient, subject to the Leonard Silk availability.
31st January is convenient.
The matter is adjourned to 31st January 2024 for defense.
As call, please. We're most grateful. To be normal. To be normal time, 9 o'clock.